Welcome to The Explainer. Today we're diving into a really fascinating legal space in South Africa, a place where ancient traditions are constantly being reshaped by modern ideas of fairness. Yep, we're talking about customary marriage.
All right, so let's just jump right in with a huge question, right? What truly makes a marriage? It seems simple on the surface, but in the legal world, especially where age-old traditions slam into a modern constitution, well, the answer is way more complex and interesting than you'd think.
Okay, so here's our game plan. We're going to start with the official rules, then we'll dig into three huge court cases that really tested the limits of tradition. Each one of these stories helps build this powerful idea that this is a law that really and truly lives and breathes. So that's the core of it, really. In a country that guarantees equality for all in its constitution, how do you legally define a marriage based on customs that are centuries old? It's a really delicate balancing act between respecting tradition and protecting individual rights. But before we get into all the courtroom drama, we've got to understand the official rulebook. It's called the Recognition of Customary Marriages Act, or RCMA, and it was this massive piece of legislation that was designed to put customary marriages on the exact same legal level as civil ones. So the act lays out these three core requirements. The first two, age and the couple's consent, they're pretty straightforward, right? But it's this third one, that the marriage has to be in accordance with customary law. Oh, that's where all the legal fireworks have happened. Let's dig into why. And this definition is just so important. The Act doesn't give you a strict checklist of rituals you have to follow. Instead, it just points to the living, evolving practices of all these different communities. Now, that flexibility is a huge strength, but it's also meant that the courts have had to step in and figure out what in accordance with actually means in today's world. Okay, this brings us to our first major legal puzzle, coming from the case of Mayele v. Nguenyama. In a polygamous marriage, where a man can have more than one wife, does he actually need to get his first wife's permission before he marries another woman? Now, what's so cool about this slide is that you can literally see the case evolving. It starts out in the High Court, and it's all about this dry, technical issue with a property contract. But as it climbs the ladder to the Supreme Court of Appeal and finally the Constitutional Court, the whole focus shifts from contracts to fundamental questions of human rights. And this quote just nails the Constitutional Court's thinking. You see, the big takeaway here is that customary law can't just exist in its own little bubble. The court ruled that the first wife's dignity and equality would be totally meaningless if she had zero say in a decision that completely changes her family life. So the court is putting dignity ahead of a strict, old-school reading of tradition. Let's see if that pattern continues. All right, let's move on to our next problem. So what happens if a really key, widely practiced ritual, like the formal handing over of the bride to her new family, what if it just gets skipped? Is the marriage still valid? Two huge cases really brought this question to a head. In both Mbungela v. Mkabi and the very high-profile Sambo v. Sengadi case, that one involved the late musician HHP. The core facts were almost identical. The lobola, or bride price negotiations, were done. The families celebrated, they clearly accepted the union, the bride was even welcomed as a makoti, a daughter-in-law, and the couples lived as husband and wife. The only thing missing was that one formal physical ceremony. The Supreme Court of Appeal was totally consistent in both cases. It decided that both marriages were in fact valid. And the court's reasoning here shows a really powerful principle. Instead of just going down a rigid checklist, the judges looked at the intentions and the actions of the couple and their families. That public celebration welcoming the bride as a makoti, they saw all of that as a symbolic handing over, which made the physical ceremony not absolutely essential. So the crucial point here is pragmatism. The court realized that if they made an inflexible, rigid rule, it could lead to some deeply unfair situations, especially for women and kids who could suddenly find themselves disinherited and unprotected just because one traditional step was missed, even when everyone involved thought they were married. Our final puzzle is from the case of Monyepao v. Ledwaba, and it's a direct clash of systems. Can you be in a customary marriage with one person and at the very same time be in a civil marriage with someone else? On this one, the law is completely unambiguous. You just can't have a valid customary marriage and a valid civil marriage with two different people at the same time. The court here was crystal clear. Miss Ledwaba's existing customary marriage was valid, so her attempt to enter into a civil marriage with someone else was legally void. In the eyes of the law, that second marriage just never happened. Okay, so we've looked at consent, We've looked at missing ceremonies and clashes between legal systems. All of these different cases, with all their different details, they all point towards one single incredibly powerful idea that the courts are using as their guide. And that idea is living law. It's a simple but really profound concept. Instead of treating customary law like some dusty old rulebook stuck on a shelf, the courts see it as something that's alive, a system that has to evolve with the very people who practice it. So what does that actually mean? It means courts have a duty to look past old textbooks and see how communities actually practice their customs today. And most importantly, they have to make sure that these modern practices are fair, just, and line up with the Constitution's huge values of dignity and equality for absolutely everyone.
So if you take just one thing away from this explainer, let it be this. Customary law in South Africa isn't being erased, it's being enriched. The courts are actively shaping it, making sure it stays relevant, and above all, that it protects the rights and the dignity of every single person in the marriage. It's a really powerful fusion of tradition and modern human rights.
And that leaves us with a final thought to chew on. This whole process of legal evolution, it never really stops. As families and technology and society keep changing, you've got to wonder, what's the next customary practice that's going to find itself in the constitutional spotlight?